welcome again to today's webinar. My name is Jabet Koros. I am a research fellow at CIPIT, which is the Center for Intellectual Property and Information Technology Law here at Strathmore University. And we are going to have a very interesting conversation about AI and its impact on creativity. So for us to start together, I'll have a brief presentation about the topic, and then I'll invite our panelist or our discussant for today to talk about more of the practical impact on creativity that AI has. So let me share my slides. All right, so as I said today, our conversation is around AI and its impact on creativity. We've seen a lot of generative AI in the creative industries, and there's a lot of impact that AI has come with. So there are many questions that it has brought about. What does it impact in terms of copyright and intellectual property? And that's what my presentation, though brief, is just going to bring out some of those aspects. Not in detail, but to give us a bit of an understanding about what the issues are, so that the conversation that we have thereafter within the perspective of Kekobo can be grounded on some of these questions. As I mentioned before, my name is Jabet Koros. I'm a research fellow at CIPIT, and CIPIT is a research and training center that's based in Strathmore University in Nairobi, Kenya. And our work focuses on the intersection of law, technology, and innovation across Africa. And we provide evidence-based research, capacity building, such as this session, and policy engagement on issues surrounding data protection, artificial intelligence, digital rights, and intellectual property, and also how these different areas of law interact and intersect. For today, we'll start with what is intellectual property. And intellectual property is a creation of your mind, and this creation of the mind is legally protected. So it is more often than not an intangible creative or innovative thing that you come up with from your mind, and then that becomes a property right. So there are different intellectual property rights. We have copyright and we have industrial property rights. Now, copyright will protect creative works. So when you think about books, when you think about songs, films, artistic works, and in Kenya, software and code is protected under copyright, as well as the compilations of data is also protected under copyright in the Kenyan law. Then on the other side, on the blue side, we have the industrial property, which protects the innovation and branding. So here you think about patents, which will protect inventions. If you think about trademarks, this protects the brands and the logos. And then think about industrial designs, which protects the look and feel of objects or products. Then we also have geographical indications, which protects the source. Rather, it gives you the source of where an item has been either manufactured or produced. So if you think about like champagne from the France region or a Swiss watch, those are what will come up in geographical indications. So here they protect the innovation, the identity, and also the commercial value. Then on another aspect, we have trade secrets, which protects confidential information. And this is often or is required to be information which is secret. And because of that secrecy has some business value, and also the know-how behind some of this commercial information or confidential information. On the other side, we have traditional knowledge and cultural expressions, which protects the community-based and protected works, the traditional knowledge or the cultural expressions that are there. So those are the different intellectual property rights that we have in a nutshell. I won't go too deep into it because our conversation today is strictly going to be on copyright. And so because of that, I'm going to talk a little bit more about what copyright is, what are the rights that are there, and what actually amounts to getting a copyright. So first we have the legal framework, which basically is in Kenya, it's under the Copyright Act, and we'll hear from Mrs. Sharon Wata from Kekobo more about what their mandate is and what they actually do around copyright and copyright registration. So importantly, for copyright, it's very different from other IP rights such as patents and trademarks, because for copyright, you get automatic protection, which means that once you have an original piece of work, which you have fixed into a tangible form. So for example, if it's a book, then you have the tangible book. If it's a software, then you have the source code. So once you have that original work that's fixed in a tangible form, you automatically own copyright in that work. But it's very important to register it. And so it's not mandatory, but it's highly recommended because this acts as your proof of ownership. Also, if you want to commercialize on your copyright, if you want to get a license, if you want to give out a license for use, or if you want to completely sell it, then you need to have that title that you may be able to transfer that ownership. So for Kenya, we have the online portal, which is the National Rights Registry. And again, Mrs. Sharon Wata will talk more about that. That is how we can register our copyright online. It's been made into a very digital and easy way to go about it. So for copyright in Kenya right now, we have protection for the lifetime of the author plus 50 years. In other countries, they have plus 70 years. And here in copyright, we have two types of rights which are granted. So one, you'll have the economic right, which will give you the control of how this copyrighted work is used, reproduced, and distributed. Also, if it's adapted, if there's commercialization around it. Then the other right is the moral right, which gives you the authorship recognition. So you are recognized as the author of the work, and this right can't be taken away from you. It also gives you the right to ensure that there's integrity in your work, which means that someone will not use your work in any derogatory form. Then what is artificial intelligence? And this is a term that's an umbrella term used to define computer systems that perform tasks normally requiring human intelligence. So the different aspects to AI. So we have machine learning, which is a subset of AI. And here's where the system learns and improves from data without explicit reprogramming. So here it's very data-driven, where it's trained on historical data sets. But the implication here is that the models can inherit or reproduce the biases from which the training data came. And so if there are errors or gaps in that data, then it's going to be seen in the model. Then our conversation today is around generative AI. And this is where text, images, codes are created from natural language prompts. And this is the one which I think most of us have actually been participating in. I bet most of us, if not all of us, have used ChatGPT or another form, maybe Gemini, etc. For the creatives in the room, there's Suno Music, which is being used to generate AI music. There's also other AI tools which are being used to generate video, artwork, and the like. And these ones are powered by large language models, or LLMs, which are trained on a vast trillions amount of internet data. Here, the risk is that it can produce biases, errors, as I mentioned before, and more importantly for today's conversation, copyrighted content. So if it's trained on content that has copyright, then it can reproduce that, which means that it can infringe on somebody else's copyrighted work. Then we have AI-assisted, where there's the human-driven work that's enhanced by AI tools. So here the role of AI is that it will support the tasks. For example, it will help you to draft, to edit, to analyze, but here the human retains the creative control and the responsibility. There's also agentic AI, which we won't discuss too much about today, but it's something that even needs to also be noted, where the AI goes further beyond generative AI and actually produces work without any prompts. So I want us to have a bit of an example of what's actually happening, what examples of AI-generated works, and the questions that come up around copyright. So here's an example I got from the internet. This is an advertisement that was run by Safaricom. And as you can see, the image is AI-generated. How you can tell it's AI-generated is that there are no clear marks. It seems a bit very smooth and all maybe one dimension. And so some of the AI generated images that we see, you can kind of tell that this is an AI generated image because of such aspects. So the impact about this is that a company that has a budget for marketing, more often than not, will have a budget for the models, right? So the models are going to be paid to come up to actually take photos and all that. And so the impact here is that, does that mean that the models are going to end up losing out in terms of this work? Here's another example. I'm sure a couple of us have seen images which are being or rather artwork that's being sold around on the streets of Nairobi in traffic, and you can clearly tell, or if you look very more or less, you can look at it, you'll see that this is AI generated. So here again, there are questions about what happens to all those artists who used to sell their hard work artwork, where they have sat for long hours to come up with this beautiful art. Where are they? We're seeing more of these AI generated images on the streets, and they're going for much less than the actual artwork that is being done by the other artists. Here's another example. There's an image of a billboard and also another image which I got from the internet. And these are also other AI generated advertisements. So the question again goes back to where the models, where is the money that was budgeted for them, what happens to them? Here's another image I came across, which is a very, very nice image. I actually really like it. It's very funny. It's a child running away from the grandmother carrying their chicken. And so this had done its rounds at some point in the internet, where there were different generations of this similar image. Now, some of you might have seen this billboard for Superloaf, where they generated this image, or rather they repurposed this image for a billboard, and it was for Superloaf. So here questions come up with AI generated content and IP questions, such as, is it an original work if AI has been used to generate it? And who owns this work? Does it mean that it was licensed? Did Superloaf license it to actually be able to use it? Did they pay for it? Who did they pay? So those are some of the questions that we are having to grapple with when it comes to AI and its intersection with copyright and intellectual property. Which brings me now to what is the impact of AI on creativity. To start off, we have to understand what the actual problem is in terms of AI and IP. So the copyright law will state that protection is done by a human, right? But then when we have AI generated work, this work is actually coming from the corpus amount of the lots of data that has already been put into. So the AI model is trained on copyrighted works, and more often than not, that work might not be consented. And then this involves scraping of a lot of music, books, images, journalism, which more often than not is actually owned by somebody. And have they given their consent? Most likely not. So the result of this is that there's no payment, there's no attribution, and there's lack of transparency. And the impact then goes to the creator. So the creator has a risk of loss of income and licensing options. Then the AI outputs will also compete with local creatives. As I've mentioned before, the artists who used to sell their work on the road are now competing with AI-generated images, which are being sold for much less than their actual work. Then there's also an issue about style imitation, which can undermine African creative identity. The image on the right is depicting, it's an AI-generated image, but it's showing the culture of this community about the face drawings, the marks, which the community has reasons behind it. It has meaning to them. So if someone is just taking that style, depicting it to maybe beautify somewhere in their house without really understanding what's behind the culture, or behind the creativity behind them, then that becomes an issue and an impact for the creators and also for the community. And it also risks the global AI exploiting the African culture without any benefit going back to the communities. Another effect is on labor and industry risks. So there's a risk of AI replacing the designers, the models that I showed you, the artists, the musicians. And this often is, the greatest risk is often on the young creatives or the informal sector workers, because that is where they are trying to earn their money. But then, as I mentioned before, if an AI generated image is going for 700 shillings and somebody who has actually painted their work is selling for 20,000, then there's that competition, and the risk is greater on the artist or the painter. So there's the rise of AI-generated content, which is flooding platforms. On Spotify, if you go, you can find an album that is fully AI-generated. And the more we have this content, then that means that it's harder for African creators to be discovered and even for them to monetize their work. So there are still opportunities. There are challenges, yes, but there are opportunities available. And AI can support the productivity, innovation, and growth of the creative. There's what we're terming as create tech, which is where businesses are integrating creativity and technology. And AI is being used as a tool for productivity, creativity, and innovation. So AI can be used for good, where it can also lower the cost of production, and that will be beneficial to the artists, to the creatives. There's also the potential of new licensing revenue streams for AI datasets. For example, there's the Noodle solution, which is an open data license, but it's an open data license that is open for everybody, but then it's equitable for the source community. So here, if you have an African data set and you want to license it out, what Noodle does is that it allows you to do that with differentiated terms, or it's a tiered system. So for a recipient who is in Africa or developing countries, and they're given a worldwide royalty-free use and share term. But if you're not from Africa or from developing countries, then you have to give back some form of royalty or a benefit to the community, to the one that give you that data. If it's for commercial use, it is allowed inside developing countries, but then outside you have to give that benefit to the community. And it works more like a Creative Commons license that we are, mostly aware of, but then it gives you that element of equity, where the community is lending of their data sets, which are being used to train the AI, especially for language data sets, then there's some benefit back to that community. So these are some of the opportunities that AI is coming with. And in my presentation, one of I have three main key takeaways. So one is that creative industries are economically significant, and they would be or should be supported by a strong copyright system. And Gen AI poses the real critical harms to the creators' livelihoods, despite offering the future of opportunities. So it's very urgent for us to protect the creators' livelihoods, ensure fair compensation, and to enable responsible AI innovation. So with that background, we'll move on to the next part. If you have any comments, any questions, please feel free to put them in the chat or put them in the Q&A, and we'll proceed with the conversation that we have. So allow me to stop sharing now and to invite our guest for today. We're joined by Mrs. Sharon Chahale Wata, who is the Deputy Executive Director for the Training and Research at the Kenya Copyright Board, or KECOBO. And she's an advocate of the High Court of Kenya. She holds an LLB from the University of Nairobi and an LLM in Intellectual Property Law from the University of Turin in Italy. She has also undertaken courses in Senior Management and Strategic Leadership Development at the Kenya School of Government, and she also lectures part-time at the university. She's an accomplished intellectual property lawyer with 18 years industry experience, having served as a copyright prosecutor, the CEO of a collective management organization, as well as an intellectual property trainer, and successfully discharged associated responsibilities. She also contributes to articles in the Copyright News published quarterly by the Kenya Copyright Board, as well as a Copyright Lawyer magazine based in the UK. She has part consultancy experience in various areas, including intellectual property law, environment law, human rights, democracy, and governance issues. Her leadership credibility and knowledge in intellectual property has been recognized and is highly dependable. And so we have a visitor with us who has a wealth of knowledge, not just in what intellectual property and copyright is, but also the actual practical aspects around it. So over the next few minutes, we're going to explore this intersection of AI, creativity, copyright law, but we'll focus more on the real experiences of the Kenyan creatives through the KECOBO's lens or perspective. So to start off and to introduce Sharon to say hello, and to tell us what Kenya Copyright Board is, what is its mandate, its role, what are its responsibilities to the Kenyan creative ecosystem. Karibu sana, Sharon.
Thank you, Chebet. Good afternoon to everybody who's online, who's on the call. It's great to have you here and great to be part of the conversation that is ongoing. Yeah, as she rightly said, I work at Kenya Copyright Board. Kenya Copyright Board is a state corporation that is created under the Copyright Act, and our mandate is to administer and enforce copyright and related rights in Kenya. So part of our functions include directing, coordinating, and overseeing the implementation of the laws and international treaties. So one of the things we do is to constantly and consistently make sure that the Copyright Act is updated. We have done several updates since the Act of 2001. 2019, we had an amendment, 2020, 2022. And right now we have put out last week a copyright and related rights bill. We are seeking to overhaul the whole act. And so we published it last week for comments from the public, and then we'll proceed with public participation. Then we also advise the government on the relevant treaties around copyright that Kenya should sign and that are good for our ecosystem. Right now, again, we are following up on the ratification of the WIPO Copyright Treaty, WCT and WPPT. And so that is part of what we do in terms of the law. We are constantly updating the law, and we are always ready to hear what the creative has to say. So kindly look out on our website and our social medias. We have published a copyright and related rights bill that we are receiving comments on, and the deadline will be 31st of March. The other thing we do is to license and supervise activities of collective management organizations. We make sure that they do the collection and distribution to rights holders of royalties in the sector of music. The CMOs we have now are in the sector of music, but you can have CMOs in text and image-based works. You can have audiovisual CMOs and any other CMOs that are relevant. We also do training programs and public education with all our stakeholders, regardless of who you are. All you need to do is ask, and whenever possible and when we can, we will come and conduct the training. Of course, sometimes we do that in collaboration with like-minded institutions like Strathmore, CPIT, CPIT under Strathmore. We collaborate with our sister organizations in the industry, universities, and any other stakeholder, really. The other thing we do is the registration of copyright, and Chebet mentioned it a bit. It is not a must, but we encourage registration because we have a responsibility to keep a database of authors and of their works in Kenya. And so we do registration of copyright through a portal, and we'll tell you more about that as we go along. The other thing we do is enforcement of copyright. So when your work has been infringed upon, you are able to come to make a complaint at Kekobo. We have a team, an enforcement team, a compliance department. It is a team of officers that have been seconded to Kekobo from the National Police Service. Some of them have consequently transferred their service to us. Others are still part of the force. They are trained in copyright law and IP enforcement. And so they're able to go out, and our act enables them to go out to do investigations, to do inspections, to do seizures, to do arrests. We were doing copyright prosecution in the past, but the mandate was taken back to DPP. But we also work in collaboration with DPP in terms of copyright prosecution matters. So basically, that's what we do for the creatives. We have in the recent past, given a lot of free services, including copyright registration, has been free for a while now. We do mediation and arbitration services. Whenever two people have an issue, they would come to us and we are able to do that. Our legal counsel, who are also IP experts, are also court annexed mediators, and we are able to offer that service. And of course, training, and legal advice for creatives. So in a nutshell, that is what Kekopo is doing or does in the creative industry.
Thank you very much for that introduction, Sharon. We are better placed knowing what Kekobo does. And you mentioned about registration of copyright. Could you please just take us through what I am a creative? How do I register my copyright?
I was muted. Yeah, we are doing registration online on nrr.copyright.go.ke. You would have to get into the portal, create an account, either an individual account or a corporate account. Corporate accounts basically are for someone who wants to register their company, for example, and it needs to be a registered company. And so when you register your account on the portal, you will need to have your KRA PIN number, your phone number, and an email. Then you create a password and you're able to register an account. Once you get in, then you can upload your works for registration. You make a new application. You would need to know what kind of work it is, which category it falls under. I have a lot of issues with sometimes how people pick the categories. Sometimes you'll find someone wants to register a book and they've picked an artistic work. So you will have to know exactly which category your work falls under, pick the right category. We will ask you details. For example, if it is a song, we will ask you who your producer is. Are there other performers? Are there other rights holders? And we'll even ask you your percentage of ownership. And we're expecting that you have split sheet agreements. So you're able to tell your percentage of ownership. And then you would submit it. So it goes through a vetting process and the approval process. Since the online process, the vetting and approval reduced significantly from about 7 days to even 24 hours or something like that, yeah? So that is how you're able to register. Again, Chebet touched on this. Registration is not a must, but it has its own benefits. You're able to prove ownership, for example, in case of a dispute. In other jurisdictions, if you have not registered your work, you will not be able to benefit from, for example, statutory damages, yeah? And I think in our bill, we have also introduced that if you want to benefit from statutory damages in case you're suing, you would have to have registered your work with us. So in a nutshell, that is how you would be able to register your copyright.
Thank you so much for that. And that's very interesting and very important. There are a few factors which I think I did not quite know. For example, what you're talking about split sheets. I think that's an important thing that people need to remember. So when you are coming up with your creative work, if you're doing it especially as a joint collaboration, then it's very important for you to ensure that you've detailed and documented all these things. Okay, so now moving to our focus for today, which is around artificial intelligence and generative AI specifically. How is AI currently shaping the creative sector in Kenya? Are there any notable trends that you're seeing? Are there any sectors which are mostly being affected by this?
Yeah, so especially being the person that does the copyright approvals, I have noted AI being used a lot in certain sectors. Film and media, you can see AI is being used in video editing, motion graphics, content creation, curation. So you're beginning to see a lot of AI being used in a lot of these works. Music, I have come across songs that are generated using AI. Artwork, of course, I have come across artworks, and you rightly put it. Nowadays, people are rarely sitting down to paint or to draw, just using AI to do that. And you can see that even with what is being sold on our streets here. And even writing, you're able to see that people are using AI a lot to write. I was in a meeting on AI, and there was a script writer who said that he is currently being helped a lot by AI to be able to write his scripts. For him, he looks at it as a tool to just assist him, cut down a lot of time in terms of time, yeah. But you're also seeing people using a lot of AI in terms of writing. So that is how currently we are seeing it shaping the creative industry. There may be other sectors that people are using AI, but those majorly are what I have observed in the recent past.
Thank you so much for giving us that experience. And you mentioned about the example where like there's a scriptwriter who's using AI. So in such scenarios, who actually owns the AI? Can the scriptwriter say that he owns the script even though AI assisted him? And can he also go and register it?
I think that's a question that we as Kekobo have also had to grapple with in terms of AI-generated works. So there's a distinction between what is purely generated by AI and then what is AI assisted, yeah? Right now is when Kekobo is coming up with some guidelines in terms of registration, in terms of registration of works that have been created using AI. Other jurisdictions, for example, the US, very clear that an AI-created work cannot be registered for copyright. However, AI-assisted works could be, but there must be a significant amount of human creativity that has gone into it. And I think for us as Kekobo, that is the same view we are taking right now. We are in the middle of amending our law, as I said, so there will be a clause on that. But also we are soon issuing guidelines specifically for registration of works. And our perspective is that there needs to be sufficient human creativity put into the work, but you need the tools to do that assessment. But also there could be a disclosure needed by the person that is trying to register the work, that you disclose that whether it is AI generated or AI assisted. For an purely AI generated work, you would have an issue with authorship, because the way our act defines authorship, it needs to be a human person. So the moment you remove the human person, then you have a problem with the issue of authorship and also ownership. And then you will also have an issue with, because copyright, as you know, gives you economic and moral rights. So when you have a work minus the human, the moral right will not definitely not apply to that work. Yeah, but this has caused us now as Kekobo to now begin to craft the guidelines and issue the guidelines, because we didn't have this before. And I noted this a lot in terms of registration. As we register our works, we do not have tools to tell you exactly, to prove to you that this is an AI created work or not. We don't have those tools yet. That is not in the system, it's not inbuilt yet. Probably it's part of the things that we are hoping to do as we update and improve the system. But right now it is not there. So I would rely on you, Chebet, to tell me that I use the AI to assist me or to generate this thing. And I'll give you an example. One time, somebody uploaded a song, and from the name, you could tell this is a male person. But when I hear the song, it sounded like a female singing. So my instinct, I thought that probably the person is assisting somebody to register, but now they're using their own name, because that happens sometimes. The people who are not tech savvy, you'll find someone to help you register, and then the person ends up registering using their name. So I called the person and I said, I'm hearing the song, but it sounds like a lady. I can tell from your names that you're male. Are you helping someone to register? And he said, no, I actually used the AI to create the song. And that's when I'm like, okay, now we are now having AI, purely AI created songs. The other example, and I was hoping that Collins would have made it to come, but seemingly did not make it. When last year we had the Raila artwork, I know all of you saw it, the Baba artwork. It was created by Collins, an artist called Collins, and he was assisted by AI, but he still had to put in an amount of human creativity to create it. Yeah. But until we spoke to him and asked about it, is when you understood what exactly happened and how he was able to use AI to do that. Yeah. And I even saw online someone else trying to use AI to create a similar thing and saying, oh, okay, so this thing really needs you to be able to know what you're doing and do something and put in an amount of creativity. So with us, we have had now to start to think about this issue and decide and now issue guidelines and also include it in our we need to include that in our amendment, copyright amendment, because initially we had not included that, but now this question has come. So our next drafting session, we will include a provision on the registration of works assisted versus created purely by AI.
Thanks so much. You've given us so many interesting scenarios and really practical what's happening on the ground. And I want to follow up on something that you mentioned. So you talked about having guidelines which explains what is sufficient. But when you say sufficient, it can be very subjective or case by case. So what, like, you can use the example of the example you've talked about Collins artwork. What qualifies as sufficient control by the author for you to get copyright protection?
Well, I can't remember everything offhand, yeah, but uh, generally the idea is this: if I remove your contribution as Chebet, can this work on its own stand as a creative work? You know, that's how you would want to look at it. Minus you, is this work still the same? Minus what you put in, is this work still the same? Is it just sitting behind a computer and saying Baba, and then the thing appears? No? Or is it you need to move this picture here and move this here and create this and put this? So that is how you would look at it. But the guidelines actually give a step, I think it's 3 steps in terms of what we'll be looking for in terms of assessment, yeah, of whether this work is AI generated or not. And again, we are hoping to improve our system so that you also have a feature within the registration system that can also allow you to detect those kind of works, yeah. The other thing with improving our system also, for example, is we want to have a plagiarism check also inbuilt within the system, so that you're uploading a book and the check automatically happens, and then it flags it out and says this is plagiarized, you know. So we want to explore ways of having to improve that system to that level, so the system is also able to assist you to do that. So for me, the major question is, if I remove Jabet from behind that AI tool, will this photo or artwork look exactly the same as the artwork when Jabet is there? Is there a way that, is there something you bring to the table or not? You know, something like that, yeah.
Okay. I have many follow-up questions because for me, I think there's need for understanding the balance where copyright is automatic, yet if you put so many guidelines or requirements, then it ends up kind of, for me, the balance kind of shifts, but that is a conversation for another day. I'm mindful of time. So I'll just ask you a few more interests that I have that maybe the other participants would also like to know. One of the other issues that we are seeing a lot is deepfakes or digital replicas. So, have there any that have been reported to Kekobo, and how is Kekobo addressing these concerns, if any?
So far, we have not had anything reported to us, but of course, in our environment, we have seen them. And I guess even something as simple as what's happening around us. When last year we had the Gen Z uprising, there was lots of videos and whatever created around politicians, around people that purport that this person has said this person has done this person is doing this. And I think we even remember the videos and the photos created around the Tanzanian president. I mean, if you really did know, you'd be like, what is she saying or what is she doing? But really, somebody has just created something to and it hurts the other person's reputation and it hurts their image and all that, yeah. So I don't think we have dealt with an issue and a reported issue yet. I'm sure they are there. Probably, maybe people do not know that they can come to make a report to us, yeah. But we have seen them around, and we have seen what they are doing in terms of security, in terms of privacy, in terms of ethics. Let me call it that, yeah.
Okay. So you mentioned about collective management. Sorry, you mentioned about collective management organizations. And you briefly talked about what their role is, but my question is more towards or focused on AI related copyrighted work. So where, say, I have rather my work has been used to train an AI, is there any recourse or is there any way that a CMO can be used to ensure that this protection for the creative?
I think in the developing world, CMOs are now expanding their mandate to address AI generated issues by licensing creative works for training, you know, like training large language models. So to me, it is another revenue stream which a CMO could assist you in terms of ensuring that you receive your royalties from that. As I said before, CMOs, their work is to license use of your work. So whenever those opportunities, I feel like AI generated works training those language models is another income stream that has come, where CMOs could take advantage and make sure that the creative they represent have licensed for that.
One other question, you mentioned enforcement as being one of the mandates for Kekobo. When you look at it from the AI perspective, are there any challenges that you see, considering you've mentioned that if there's no technology to identify the AI being used, how then can you ensure that there's some form of enforcement where there are those gaps? And in your opinion, what can be done?
I think there's a big gap in terms of first having the tools, having the trainings, having the legal framework. I saw recently there is an AI bill that is being proposed. Unfortunately, quick skim through it, I didn't see any IP issues, IP related issues addressed in that bill. And I know for sure, like for Kekobo, we were not involved as the stakeholders in that, yeah. But I think there's a need to involve every stakeholder so that you come up with something that is very inclusive, yeah, and that would address IP and enforcement, yeah. So for me, there's needed the enabling legal environment that has to be worked on, training, because even if you are able to do that, you would need to train the enforcement officers. This is a new area, an emerging area. Nobody is yet an expert there, so you would need to do a lot of training and yeah, collaboration with all the stakeholders that are involved. Yeah.
Thank you for that. So I want to get a feel of what the participants have to say about this AI and its impact on creativity. We have two polls. So the first one, so should AI generated works receive copyright protection? Could be yes, no. We've talked about human involvement, as Sharon has mentioned. So what is your view? Okay, so 15% say yes, 18% say no. Majority say only if there's human involvement. I'm glad that maybe some minds have been swayed after our discussion, but that's good to know. So our second question, what is the biggest AI concern for creators? What is the biggest AI concern for creators? Is it loss of income, loss of credit, so where you're not being known as the author or the owner of it? Misuse of cultural works, where our culture is being used by AI to train it, our language is being taken, and there's no benefit back to us? Or is it a lack of regulation? And so there's a lot of confusion around what actually is happening. Okay, so we have the majority saying that loss of income is the biggest concern. 23% say loss of credit, 27% say misuse of cultural works, and 46% say lack of regulation. And these are very important things, which we don't have enough time to delve into each one of them and see what the economic loss is, what the moral rights that are affected are, what the cultural works misuse, the effects of all these things are on our community, on the creative industry, and on how it grows. But we have another opportunity for you to understand in detail more about this in form of a workshop or a masterclass towards the end of the last quarter of the year. We'll put a form in the chat where you can respond to that and indicate whether you'd like us to contact you to join that. We'll also have another session where we'll go into how AI is impacting innovation. And so here it's going to be about, can AI invent? Can you have a patent based on an AI invention? And what are all the challenges and the intersections that come about that? So look out for our call on that, and we'll have another session, an interactive session where we can engage further on that front. I'm very mindful of the time, and so we'll just I'll take two questions from the chat. In a scenario where a vendor agreement grants the vendor IP rights over all derivative works, what contractual or legal mechanisms can a company use to secure ownership of those derivative works?
Okay, for derivative works, you need permission from the original owner of the original work. So you have to have a license or have bought or have an assignment from the owner. A derivative work basically is a work derived from an original work. So for example, I have a book and someone wants to do a movie. The movie would be a derivative work. Someone wants to do a translation, it would be a derivative work. You would have to have permission of the owner, of the original owner, in form of an assignment or a license. So for that, for me, if you have the license or the assignment or permission in writing, then you're covered in terms of accessing it legally. But if you do not have a license, an assignment to make a derivative work from an original, then that is definitely an infringement.
Asante. There's a two-in-one question for Sharon. I think one is more to get clarity on what you mentioned about the DPP taking up the function of copyright prosecution, I think is what you said. And then the other one is discussing about the copyright bill and whether it reconciles with the AI bill.
Yeah, so with the first question, I am actually seeing the question. She seems to have mixed up two issues in one about statutory damages. So this is the thing. You are copyright protected once you create. You don't have to register. Yeah. But in some jurisdictions, if my work was infringed upon and I went to court, I would get general damages or whatever. But then there's something in the law that's called statutory damages. You can only get that, for example, in the US, if you have registered your work. So that is what I meant when I was talking about statutory damages and the benefits, some of the benefits for registration. So in the US, if your work is registered, when you go to court, among other damages you can also get statutory damages, but you have to have registered your work. Now, she's talking about then the DPP taking over the function. Yes, we had a prosecution function that was delegated prosecution. We were gazetted as copyright prosecutors specifically. So all copyright infringement matters that were happening, we were the ones doing prosecution. But around 2020, DPP took back that role to DPP. So we no longer do copyright prosecution, but whenever we do investigations and arrests and whatever, then the file will end up at DPP so that copyright prosecution is done now by the DPP office. That's all I meant, yeah? But I see she's mixing that with statutory damages, which is a bit confusing. So then she says, when did they shift? Okay, no. Does this fall purely under criminal? Yes, of course, they are criminal. There's criminal and the civil, of course, you know that. So once you come and report an infringement to us, for example, a publisher comes to us and says, my books are being pirated in River Road. So our officers will go to the place, they will investigate, they will enter, because our act gives them the power to enter, to inspect, to seize infringing material, to arrest. So they will do all that, and then they will come back, and once the matter is taken to court, it is taken to court under a criminal matter. Then there is that I'm saying Chebet is infringing on my copyright. I want to sue her. For example, the case that was between Nonini and somebody, where Nonini was suing for use of his song in an advert without permission. And he was awarded first 1 million, and I think on appeal 4 million. So that is a civil matter. We were only doing the criminal matters, which we still do, but we now do them up to arrest, investigation, arrest. Then prosecution now is done by DPP. Initially, that's what I meant earlier. We were doing the whole package until prosecution. Then she talked about what of in the case of no registration. Oh yeah. I've already said, even if you have not registered and your work is infringed upon, you can go to court, you can sue. It can be a criminal matter, it still doesn't matter, yeah? Is there a concurrent effort to reconcile the bill with the new AI bill? We are not the movers of the AI bill, and and we were not part of the stakeholders drafting it, but Kekobo would like to get involved in terms of the bill that has already been tabled. So I'm sure we'll move through the channels to try and be part of the stakeholders on that.
Thank you very much. I'll just respond to a few questions that came in the Q&A. So there's one which talks about traditional cultural expressions, stating that the copyright of which would have expired. So for this, we have an act specifically for the traditional cultural expressions called the Protection for Traditional Knowledge and Traditional Cultural Expressions. So it's separate from Kekobo. Kekobo does have the mandate to keep a registry, if I'm not wrong, but a repository. So this will fall under the ambit of the act. And this one talks about benefit sharing and consent from the community. So it's a bit separate from this, and the AI issues will be there. The license that I talked about, the nodal license, takes this into it takes this into rather it focuses on this because it's talking about where there's ownership of language, which is a communal, traditional cultural expression. And so it responds to AI data sets, which are language data sets, and how the community can get a benefit from it, at the same time providing access to this data. So that could be one of it, rather a response to that. Lastly, there's one person who talked about deepfakes and said that rather asked if they can be used in the context of image rights. Yes, they can. And mentioned that Kekobo once gave a directive on the same, and is it planning to issue guidelines with respect to that? So I'll let Sharon answer that, but then we have a lot. This topic talks a lot about very many different aspects which are interrelated. And 1 hour is definitely not enough for us to go through all this, which is why I encourage you to fill in the form that's going to be put in the chat. Give us your consent to reach out to you when we have the masterclass, which will take you through all these other different elements, bring in all these issues and questions that you are asking, and to enable us to understand what this intersection is and how can you actually maneuver around it. So I'll let Sharon answer that as she's giving her parting shots, and then we'll wrap it up.
Yeah, we are constantly planning to give directives or guidelines concerning any emerging issues and anything. So look out on our social medias for any guidelines, any directives that we issue around the same. I think my parting shot would be, we would really appreciate to get comments on our draft copyright and related rights bill. It is like a whole overhaul of the Copyright Act, trying to navigate emerging issues, cover everything that we need to cover. So we would really appreciate comments from anyone from the public concerning that. They're on our social medias. If you check YouTube, we are Kenya Copyright Board, X, the same, Instagram, Facebook, Kenya Copyright Board, Kenya Copyright Board. And also for you to feel free to reach out to us on info@copyright.go.ke with questions. You can visit our offices. You can reach out to us with any issue, basically. Yeah.
Asante sana sana. Thank you very much, Sharon. Thank you for joining us. Thank you for sharing all the wealth of information that you have. Very many examples which, had we not had them here, we probably would not have known or understood them. So thank you very much for taking your time to join us. Thank you very much to all the participants who have joined. We look forward to seeing you in the next session. We also run an AI webinar series, which talks about AI governance and AI policy. And we also welcome you to join that. Looking forward to seeing you in the next one. Thank you very much and have a very good afternoon.